The courtroom was loud just seconds before. Papers shuffling, reporters whispering, cameras ready. Then suddenly, silence. A federal judge literally froze mid-sentence. All because of 7 unexpected words spoken by one woman, Pam Bondi. No one saw it coming. Not the attorneys, not the press, not even the defendant. What she said didn't just interrupt the hearing, it changed the direction of the entire case. It was supposed to be just another procedural hearing in a high-profile federal case, the kind of hearing that rarely makes front-page headlines, the kind where lawyers debate technical details, judges review motions, and everyone in the room expects a long, methodical day. But the atmosphere inside the courthouse told a slightly different story. By 8 a.m., the hallway outside the courtroom was already crowded. Journalists stood shoulder to shoulder, balancing notepads and cameras. Producers whispered into phones. Legal analysts rehearsed live commentary. Inside, spectators filled every wooden bench. Some were there out of professional interest. Others were drawn by curiosity, aware that this case, though procedural today, had already stirred national conversation. At the center of it all was a legal team led by Pam Bondi, a figure no stranger to high-stakes legal battles. Her presence alone had drawn additional media attention. Supporters saw her as sharp and strategic. Critics saw her as politically calculated. But no one doubted one thing. She understood how to command a courtroom. The case itself had been building for months. Allegations of misconduct, accusations of financial irregularities, claims that, if proven true, could have serious consequences. Political tension hovered over every development, with commentators debating the broader implications on nightly news panels. Still, today's hearing was expected to focus on procedure, timelines, document submissions, admissibility standards, the kind of legal groundwork that feels technical but rarely dramatic. At precisely 9 a.m., the courtroom doors closed. A hush settled over the room as the judge entered from chambers. Everyone rose. The scrape of chairs echoed against marble walls. The judge nodded briefly and took his seat. "You may be seated." His tone was calm, almost routine. He adjusted his glasses and began reviewing the docket in front of him, page after page, motion after motion. The prosecutors were first to speak. They stood confidently, outlining their position with measured clarity. They referenced prior filings, emphasized procedural compliance, and argued why certain evidence should remain included in the record. Their delivery was polished and rehearsed. Then came the defense. They countered point by point, challenging interpretations and questioning the timing of certain disclosures. Their argument was equally composed, equally precise. To an outside observer, it might have felt like a chess match played with legal language instead of pieces. Back and forth it went. The judge interjected occasionally, asking for clarification here, requesting citation there. His expression remained unreadable. This was familiar territory, controlled, structured. Reporters typed steadily, but without urgency. There were no dramatic objections, no raised voices, just disciplined advocacy. After nearly an hour, the arguments began to wind down. The judge leaned back slightly in his chair, reviewing his notes. It seemed the morning would continue exactly as expected. Then came the moment. The judge looked up and scanned the courtroom. "Counsel," he said, directing his attention toward Pam Bondi's table. "Is there anything further before we proceed?" It was a routine question. Judges ask it all the time. It's often answered with a simple, "No, Your Honor." But something subtle shifted. Pam Bondi didn't respond immediately. She didn't shuffle through papers. She didn't whisper to her co-counsel. Instead, she slowly rose to her feet. That alone drew attention. In high-level proceedings, body language matters, timing matters, and the deliberate nature of her movement did not go unnoticed. A few reporters paused mid-sentence, fingers hovering above keyboards. Bondi stood straight, shoulders squared. She clasped her hands lightly in front of her. Her expression wasn't dramatic, but it wasn't casual either. It was focused, intentional. The judge tilted his head slightly. "Yes, counsel?" The room felt different now, subtly but undeniably. Even the air seemed heavier. The defense team exchanged brief glances. One attorney adjusted his tie. Another leaned forward, as if bracing for something unscripted. Because experienced courtroom observers know this, when a seasoned attorney hesitates before answering a routine question, it usually means the answer won't be routine. Bondi took a measured breath. In that second, the faint hum of the courthouse ventilation system became strangely noticeable. A cough in the back row sounded louder than it should have. Every eye was on her. The judge's pen hovered just above his legal pad. The prosecutors sat upright, alert, and somewhere in the gallery, a camera lens slowly zoomed in. No one could have predicted that the next few words would completely alter the tone of the day. What had begun as an ordinary procedural hearing, predictable, controlled, almost technical, was about to transform into something else entirely. Something no one had prepared for. And as Pam Bondi finally opened her mouth to speak, the courtroom braced for impact. Pam Bondi slowly stood up. She didn't shuffle papers. She didn't glance at her legal pad. There was no frantic whispering with co-counsel, no last-second adjustment of documents. Instead, she lifted her chin slightly and looked directly at the judge. Her posture was steady, controlled. In high-profile cases like this, every movement is calculated, and this one felt deliberate. Her voice, when she finally spoke, was calm, but firm enough to carry across the entire courtroom. Your Honor, the state has uncovered evidence that fundamentally changes the integrity of these proceedings. The sentence didn't echo loudly. It didn't need to. It hit the room like a thunderclap. For a brief second, no one reacted. It was as if the words needed time to register. Then the shift happened. The quiet murmur that usually fills a courtroom vanished. The faint clicking of reporters' keyboards stopped mid-typing. One journalist froze with his fingers suspended over the keys. A camera operator slowly lowered his lens, sensing that something far more serious than routine argument had just unfolded. At the bench, the judge leaned forward. His expression changed, not dramatically, but noticeably. His eyebrows narrowed just slightly. His pen, which had been resting against his notepad, stilled in his hand. "What exactly are you referring to, counsel?" he asked carefully. The question was neutral in tone, but the weight behind it was unmistakable. In the gallery, spectators leaned in. A woman in the second row clasped her hands together. One of the defense attorneys adjusted his glasses, his jaw tightening. Pam Bondi did not rush her response. She paused. Not long enough to appear uncertain, but long enough to make the silence uncomfortable. That pause was powerful. In a courtroom, silence can be louder than argument. And this silence stretched thin, like a wire pulled tight. When she spoke again, her words were even more precise. "We have reason to believe that key testimony presented earlier may have been materially misleading." The phrase materially misleading hung in the air. In legal language, those two words carry enormous weight. They don't suggest a minor inconsistency. They suggest something substantial, something capable of influencing decisions, rulings, perhaps even the outcome of the case. A sharp gasp broke from somewhere in the back row. Whispers followed, spreading like ripples through water. A defense attorney dropped his pen. It clattered against the wooden desk, the sound startling in the otherwise silent room. He quickly picked it up, but the damage was done. The tension was visible now. The judge's voice came again, slower this time. "Counsel, are you alleging that this court has been presented with false testimony?" It was a careful choice of words. Judges do not leap to conclusions. They clarify. Bondi maintained eye contact. "We are alleging, Your Honor, that newly obtained documentation contradicts sworn statements previously submitted." There it was. Not speculation, not rumor, documentation. That single word shifted everything. On the prosecution side, attorneys began flipping through binders urgently. One whispered sharply to another, clearly caught off guard. A third reached for his phone under the table, likely sending a rapid message to colleagues outside. The defense rose almost immediately. "Your Honor," one attorney began, his tone tight but controlled, "we object to the characterization of any prior testimony as misleading without immediate presentation of the alleged documentation." His voice was steady, but his urgency was unmistakable. This wasn't just a disagreement over interpretation anymore. This was an accusation that could shake the foundation of the entire case. If sworn testimony had been contradicted by hard evidence, it could mean motions to strike. It could mean sanctions. In extreme cases, it could mean perjury investigations. The judge raised his hands slightly, signaling for quiet. The courtroom obeyed. Even the restless shifting of chairs stopped. "Counsel," the judge said to Bondi, "does the state have these documents in its possession at this time?" "Yes, Your Honor." "And when were they obtained?" "Within the last 48 hours." Another ripple of murmurs spread through the gallery. 48 hours. That meant this development was fresh, unexpected, potentially explosive. The judge exhaled slowly. His gaze moved from Bondi to the defense table, then briefly toward the gallery packed with reporters. He understood, as everyone did, that whatever happened next would not stay confined within these walls. "Approach," he instructed. Both legal teams moved toward the bench. From the gallery, observers could not hear the conversation, but the body language spoke volumes. Bondi spoke steadily, handing over what appeared to be a folder. The defense attorney gestured firmly, at one point shaking his head. The judge listened, flipping through pages. Seconds felt like minutes. Reporters strained to catch fragments of words. One quietly slipped out of the room, likely racing to alert a newsroom that something major was unfolding. When the attorneys returned to their tables, the energy had completely changed. This was no longer a routine procedural hearing. It was now a question of credibility, of truth, of whether the very integrity of the proceedings had been compromised. The judge looked out over the courtroom, his expression composed but serious. "This matter," he said carefully, "is of significant concern." And in that moment, everyone in the room understood. The case they thought they were watching had just become something entirely different. The judge's face tightened. It wasn't dramatic. Judges are trained to maintain composure. But in that subtle shift, the slight narrowing of his eyes, the firm line forming across his mouth, you could see the weight of what had just been said. "Are you alleging misconduct?" he asked carefully. He chose each word with precision. In a courtroom, language is everything. Misconduct isn't a casual term. It carries legal consequences, professional consequences, even criminal ones. All eyes turned to Pam Bondi. She didn't hesitate. "I'm stating, Your Honor, that we have obtained documentation that contradicts sworn statements previously submitted to this court." Her tone was steady, not emotional, not aggressive, certain. And certainty can be far more unsettling than outrage. You could feel the temperature in the room change. It wasn't literal, of course, but the shift was undeniable. Moments earlier, the courtroom had been structured, procedural, almost routine. Now it felt charged, tight, unpredictable. Reporters snapped into motion. Phones appeared instantly. Thumbs flew across screens. One journalist slipped out into the hallway, already whispering into a headset. "Possible contradictory testimony. Yes, documentation. This is serious." Spectators exchanged stunned looks. A man in the back row mouthed, "Wow," to no one in particular. Another leaned forward so far he nearly slid off the bench. At the defense table, the reaction was immediate. One attorney rose halfway out of his seat before fully standing. His expression was controlled, but the tension was visible in his jaw. "Your Honor," he began firmly, "we request immediate clarification. Such a serious allegation requires immediate presentation and examination of the supposed documentation." He emphasized the word supposed. Another defense attorney chimed in. "We object to any implication that sworn testimony was improper without full evidentiary review." The courtroom volume began to rise, not into chaos, but into overlapping urgency. The judge raised his hand. Silence. It fell instantly. And then something unexpected happened. He said nothing. For several long seconds, the courtroom existed in absolute stillness. No shuffling papers, no whispering, no typing, just silence. And that silence felt heavier than any argument that had been made all morning. The judge looked down at the bench, then toward the folder that had been handed to him moments earlier. He didn't open it yet. Instead, he seemed to weigh something internally: procedure, fairness, consequence. When a judge pauses like that, it means the moment matters. Because what he decided next wouldn't just impact the flow of the hearing, it could affect the entire direction of the case. He looked first at Bondi, then at the defense, then briefly toward the gallery filled with media. Finally, he spoke. "Court is temporarily recessed. I will review this matter immediately." The gavel struck. The sound cracked sharply through the room. Under normal circumstances, a recess triggers instant motion. Lawyers gather papers, reporters rush out, spectators stretch, check phones, chatter excitedly. But not this time. No one moved. It was as if the room needed a second to absorb what had just happened. Because if Bondi's claim was accurate, if documentation truly contradicted sworn testimony, this wasn't just a procedural hiccup. This was a potential turning point. At the prosecution table, attorneys leaned in close, speaking in urgent whispers. One pointed toward the folder now in the judge's possession. Another scanned through notes rapidly, likely reviewing prior testimony line by line. Across the aisle, the defense team huddled tightly. Their posture was no longer relaxed or strategic. It was defensive, calculating. One attorney rubbed his temples. Another stared straight ahead, expression unreadable. In the gallery, spectators finally began murmuring quietly. "What does this mean?" someone whispered. "Could the case collapse?" another responded. A legal analyst seated near the back shook her head slowly, jotting something into a notebook. She understood the gravity. Allegations of contradictory sworn statements don't just slow cases down, they complicate them. Near the courtroom doors, a reporter stepped outside and immediately began a live update. "We've just seen a dramatic development inside the courtroom. Proceedings have been paused after claims of newly discovered documentation that may contradict prior testimony." Inside, the judge had already exited through the side door to his chambers. Behind that door, the real evaluation would begin. Judges do not call recess lightly in moments like this. It signals that something requires immediate, careful review. It suggests that the integrity of the process itself may be at stake. Back in the courtroom, time seemed suspended. 5 minutes passed, then 10. No official updates. Every second of waiting intensified the tension, because everyone understood the stakes. If the documentation proved insignificant, the hearing would resume and move forward. But if it revealed genuine contradictions in sworn testimony, there could be motions to strike, sanctions, even potential investigations. The routine hearing that had started like any other had now entered completely different territory. And as the courtroom waited in heavy anticipation, one thing became clear. Whatever the judge decided when he returned, this case would never feel routine again. During the recess, the courthouse no longer felt like a quiet government building. It felt like the center of a storm. Both legal teams immediately separated, gathering in opposite corners of the hallway outside the courtroom. Their voices were low but urgent. Assistants rushed back and forth carrying binders, laptops, and stacks of highlighted transcripts. Speculation spread fast. What was the evidence? When exactly had it been discovered? Why hadn't it been presented earlier? And perhaps the most pressing question of all, how damaging was it? Near a row of tall courthouse windows, members of the prosecution team formed a tight circle. At the center stood Pam Bondi, speaking calmly while others flipped through digital files on tablets and phones. One attorney pointed to a specific page in a transcript, comparing it to what appeared to be newly printed documentation. Their movements were focused, not frantic, but undeniably intense. Across the hall, the defense team looked equally determined. One attorney paced slowly while speaking into his phone. Another had a laptop open on a bench, scrolling quickly through previous testimony. A third was reviewing what seemed to be a timeline chart, tracing dates with a pen. If this new documentation contradicted sworn statements, they needed to know exactly how and fast. Meanwhile, reporters filled the hallway, trying to piece together fragments of information without direct access to the documents. Snippets of conversation drifted through the air. Material contradiction, 48 hours ago, could trigger a motion to reopen testimony. Within minutes, news alerts were already circulating online. Legal analysts on television began speculating in real time, though none of them had seen the evidence itself. Sources later described the atmosphere as electric, not chaotic, but charged. Every conversation felt urgent. Every glance seemed loaded with implication. Inside chambers, behind closed doors, the judge began his own review. Unlike the hallway, his space was silent. Court officials moved quickly, retrieving official transcripts from earlier hearings. Exhibits were brought in. Digital records were accessed. The newly submitted documentation was laid out carefully across the desk. The judge reportedly examined the materials personally, comparing line by line the sworn testimony previously given with the new evidence presented during the hearing. In moments like this, precision matters. If the contradiction was minor, an error in wording, an ambiguous phrase, it might not warrant significant action. But if it directly conflicted with sworn statements in a meaningful way, the implications could be serious. Time stretched. 10 minutes passed, then 20, then 45. In the hallway, the tension didn't fade. It intensified. At one point, a clerk stepped out of chambers to retrieve additional transcripts. That brief appearance reignited whispers among the press. "They're digging deeper," one reporter murmured. Nearly an hour after the gavel had struck, the courtroom doors reopened. A court officer announced that proceedings would resume. Everyone filed back inside, but the mood was no longer routine. Earlier that morning, the room had felt structured and predictable. Now, uncertainty filled every corner. Even the simple act of taking a seat felt heavier. The judge entered. This time, no one needed prompting to rise quickly. When he sat down, his expression was composed, but unmistakably serious. He adjusted the documents in front of him, glanced briefly at both legal tables, and then addressed the room with measured clarity. After reviewing preliminary materials, he began, "This court finds sufficient cause to pause the current proceedings pending further verification." The words were calm, controlled, but their meaning was enormous. A pause in proceedings is not routine. It signals that the court sees potential issues serious enough to halt forward momentum. The judge continued, "This matter requires additional examination to determine the accuracy and relevance of the newly presented documentation. There would be no immediate ruling on guilt or innocence, no dramatic dismissal, no explosive confrontation. Instead, there would be scrutiny. That meant delays. It meant further review of transcripts and evidence. It meant potential evidentiary hearings to determine whether testimony had indeed been materially inconsistent. And it meant that if any party had knowingly submitted inaccurate sworn statements, consequences could follow. Possible sanctions, professional discipline, even referrals for further investigation, depending on the findings. At the prosecution table, there were subtle nods of acknowledgement. At the defense table, expressions remained guarded but focused. The gallery was silent. Everyone understood that something significant had just happened, not because of a dramatic outburst, but because of a deliberate decision to slow everything down. In high-profile cases, momentum often drives public perception. A pause interrupts that momentum. It creates space for doubt, for re-evaluation. As the judge finalized scheduling details for further review, it became clear that this case had entered a new phase. It was no longer just about the original allegations. Now, it was also about credibility, about the reliability of testimony, about whether the integrity of the courtroom itself had been compromised. And as the session adjourned once more, one reality settled over everyone present. The consequences of this pause could reach far beyond a single hearing. Because when a court stops to question the foundation of its own proceedings, the impact is never small. What happened in that courtroom wasn't just dramatic, it was significant. In the legal world, drama can fade. Headlines come and go. But significance? That lingers. When a judge halts proceedings over potential integrity concerns, it sends a message far beyond the four walls of the courtroom. It reminds everyone, lawyers, defendants, the public, that the legal system stands on one foundation above all else: truth, credibility, trust in sworn testimony. Without those pillars, everything else begins to crack. When the judge paused the case to review the newly presented documentation, it wasn't about theatrics. It wasn't about politics. It was about protecting the integrity of the process itself. Because if testimony had indeed been materially misleading, the consequences wouldn't be minor. It could affect prior rulings already made in the case. It could impact plea negotiations that may have been based on certain assumptions. It could even influence the ultimate outcome of the trial. In some situations, contradictions in sworn statements lead to reopened hearings. In others, they trigger sanctions or separate investigations. And sometimes, they completely shift the balance of leverage between opposing sides. Legal analysts later explained that moments like this are rare, but when they happen, they reshape cases entirely. A single revelation can change strategy overnight. The side that once felt confident may suddenly find itself on the defensive. The side that appeared cornered may gain unexpected momentum. Public perception can pivot in hours. And in high-profile cases, perception often carries enormous weight. For viewers watching the news later that evening, it looked like just another courtroom headline, a breaking news banner, a short clip, a panel discussion filled with speculation. Commentators debated what the documentation might reveal. Some downplayed it as procedural maneuvering. Others called it a potential turning point. But for those who were inside that room, it was unforgettable. They remembered the silence first. Not the words, but the silence after them. The way reporters froze mid-sentence. The way attorneys stopped flipping through their notes. The way even the smallest sounds, a shifting chair, a clearing throat, felt amplified. They remember the tension, the subtle tightening of expressions, the careful, deliberate tone in every response that followed. They remember the weight of those words, documentation that contradicts sworn statements. In a courtroom, those words don't just hang in the air, they linger. 7 sentences turned an ordinary hearing into a historic moment. 7 sentences transformed routine procedure into a pivotal crossroads. And whether the new evidence ultimately proves decisive or not, the impact of that moment cannot be erased, because something fundamental changed. The case was no longer just about the original allegations. It became about credibility, about whether the truth presented under oath matched the facts behind the scenes. That shift matters. It changes how attorneys prepare. It changes how judges scrutinize filings. It changes how the public interprets every future development. And at the center of it all was Pam Bondi. When she stood up that day, she didn't raise her voice. She didn't argue aggressively. She didn't dramatize her claim. She simply stated it, calmly, directly. And sometimes, that kind of delivery carries more power than any emotional appeal ever could. In the end, courtroom history is often shaped not by shouting matches or fiery objections, but by quiet, deliberate statements that force everyone to pause, to reconsider, to re-examine. The judge's decision to halt proceedings underscored a fundamental truth about the justice system. It is designed not just to reach outcomes, but to reach them fairly. That requires vigilance. It requires accountability. And occasionally, it requires pressing pause when something doesn't add up. For weeks, perhaps months, the ripple effects of that moment would continue to unfold. Additional hearings, further reviews, strategic recalculations behind closed doors. But the image that will remain etched in memory is simple. A packed courtroom, a routine question, a calm response, and then silence. Because sometimes the most powerful moments in the justice system aren't loud, they aren't chaotic, they aren't explosive. Sometimes they happen in complete stillness. If you enjoyed this deep dive into real courtroom drama and high-stakes legal turning points, make sure to like, subscribe, and turn on notifications so you don't miss our next story. Because in the world of law, power doesn't always shout. Sometimes it stands up quietly and changes everything.